Okay, so I bring this up because I just feel like the Killian case is paramount to understanding contract law because it covers so much. It looks at contracts, it looks at offer, it looks at acceptance, it looks at consideration, but it also looks at conditions. It also looks at um, equitable claims. All of these things play a vital role in the judge's final decision. And again, these are 12 pages that are semi-difficult to understand at first blush. And so I thought what we could do today is start off this lesson just with a short discussion about some general issues about the case, and then um, I have a couple of options from there. So before we get going, can anybody just volunteer to tell the class kind of what the main issue is? Like, what's going on with this case? What are they doing? You don't have to give the details. You don't have to understand what shred and cost is, like some random like nitpicky things in this case are, but just give us an overview about, what's going on with Killian versus Ricchetti. All right, Jeremiah, you want to take a stab at that?
Yeah, sure. I guess essentially what happened is that two guys who love real estate development were like, "Hey, let's get together." And so they had a bunch of communication back and forth, and then essentially one party thought that they were in a contract, the other one did not, and then so the party who did think that they were in a contract sued the other one because the Ricchetti sold the property before issues of the contract happened.
Yeah.
Um, and then Killian was all ticked off, which I think he has a right to be, but because he didn't get any money out of it, which legally it seems totally legit legally, but I feel that Killian still got screwed. But anyways, Ricchetti was denied his motion for summary judgment because
Uh-huh.
because they still had facts for like the promissory estoppel
Yeah.
and things like that. But he was granted his motion for summary judgment on breach of contract because there was no actual contract made upon the three conditions that we learned.
Yeah. Okay, perfect. Yeah. Yeah, you're talking about, and you got it. You got a lot of these main issues. So that's awesome. So at this point, I want to pull up a quick little slide that I think will kind of help you see I did some background investigation on this actually. So let me present this slide right here that you're looking at. And a lot of this kind of comes back to what Jeremiah said. Here, what I've done is through the miracle of modern technology, I went and actually found Killian's condo on Pine Street. I wish you were more impressed with me, but and here's kind of the catch. I don't know if it's the red one or the blue one. I think, but it's one of those two, right? But this is Pine Street. This is downtown Philadelphia, well, close to downtown Philadelphia, and these are valuable properties, which was important as Jeremiah was talking about, because part of the money from the sale needed to fund his Killian's ownership share when he bought into the LLC with Ricchetti. By the way, some student told me I was pronouncing it Ricchetti, but really it's Ricchetti. And then somebody else said, no, it's probably Ricchetti. I'm just going with Ricchetti. All right. But if you call him Ricchetti, I don't care. All right. But yeah, this is the condo. So the condo on Pine. And then this is really cool. I pulled up Google World or Google Maps and got the satellite view here before it was developed. This is that vacant lot on the corner of 2nd and Brown, as you can see on your screen. So now it's got a yoga. Apparently, it's got a yoga studio on one of these 6 floors that was eventually developed. But as you can see, not that long ago, this was a vacant lot on 2nd and Brown. Again, this is closer to downtown Philadelphia right there. Valuable property. So again, just take a moment to appreciate I'm basically Sherlock Holmes. I found all of this. You're welcome. All right. So with that, then we've got, as Jeremiah was saying, now we've got the contract issues. And I love the way that the judge queued up this decision, basically by saying, like, lots of people enter into agreements in hopes that it's going to, return, um, you know, have a valuable return on their investment. And it doesn't always turn out that way, right? And it definitely didn't turn out that way if you're Killian in this case. And to help you understand this, I've got a quick poll. I'm gonna poll you guys real quick here. I want to see, because I've got a couple options. One, I can talk about the case, and we'll go back and forth about the various emails and where's the offer and where's the acceptance. But I also thought it might be valuable today, since this is only your second case that you've read, in the form of a judicial decision. I'm curious if you kind of like to see me model this a little bit first. And so anyway, I'm gonna pop this poll up real quick. And I'll just give you a couple seconds, because what I can do is I can model this case for you and how I read it and how I mark it up, or I can just discuss it otherwise. So if you want me to just, as a class, discuss it, click no. But this is over what, like, it's 100% yes. So, okay, one person voted no, but it's still 98% want me to model it. So, all right. Unless I'm seeing a here, it's impossible. Like, I'm calling the state of Florida for whoever. All right. So it's 95% want me to model something. So, in case you had voted that way, I've got it queued up. So let me share my iPad with you real quick. And all right, like it, Jared. I just saw Jeremiah's chat. Okay. All right, so what I've done here is, I've just, on my iPad, I've pulled up a copy of the case, and this is what you read. And I've got some markups already, but I'll talk about it as we discuss. So let me make sure my stylus pen is working here, and let's just go through this fairly quickly, but hitting the main points. Okay, so you can follow along if you printed this out, or if you have it on your screen, go ahead and follow along with me. All right, again, just pointing out a couple things. Judicial decisions are always going to be kind of queued up like this. You'll have the name of what we call the plaintiff, and down here the name of the defendant. So it's Killian that's suing, and that makes sense because Killian's the one that is basically getting screwed in this agreement. And these, by the way, are the symbols. Sometimes you'll use just a regular P, like if on our slides I'll just put a regular P, and then for the defendant sometimes I'll just have a D, but nonetheless you can use the delta if you want. And then here you'll have the date. This is a recent case, well, relatively, not even 4 years old. And anyway, okay, so I'm getting too excited about the mechanics. Let's move on, and I want to show you kind of the issues. Now, Kearney, this is the name of the judge right here. Not important for our purposes, but just so you know. And as I scroll down here, the judge does an incredible overview of telling you everything you need to know about the case in the first paragraph. So that's why I highlighted this. Often is shown today, friends enter into email exchanges, and you now know, can you enter into a contract via an email? Yes, everybody's nodding their heads, yes. Okay, can you do it with a thumbs up, with a nod, with a, yeah, of course. Like, you can do all of that stuff. With a grunt, you can enter into a contract. Okay. But email, that's nice because then it's documented at least. But again, high hopes, When the realities do not meet the expectations expressed by one friend in emails, courts must review whether the friends actually reached a meeting of the minds. Okay, and that's going to be important. It's going to come back to that. A meeting of the minds of any enforceable term. All right, so that's the first issue. Was there a meeting of the mind? That's why I've got this one right here. Two, even with a meeting of the minds, you may have a condition that never happens. And if that condition never happens, then you don't have a contract. So I could enter into an agreement with Jeremiah and say, Jeremiah, you can mow my yard today and I'll pay you $20 if it rains before 2 o'clock in the afternoon or something like that. And if it doesn't rain before 2 o'clock in the afternoon, we may have an agreement, but it doesn't come into effect unless that condition occurs. So that's number two. Again, super important. I love this judge. This is a perfectly written opinion. And then three, the kind of the final thing here is the law allows, even absent an enforceable meeting of the minds, a party who lost money on reliance for a specific promise to recover money as a matter of equity. And you've heard me talk about equity before. That's like there used to be the equitable courts back in 14th century England, and we don't really have that anymore, but we allow equitable claims in our courts today as well. And this, whenever you hear equity, I just want you to think like fairness. That's what equity is about. Maybe there's not a contract, but it wouldn't be fair for somebody not to get some amount of money or damages, recovery in the lawsuit itself. All right, those are the three main issues here. And like I said, the judge lines it up perfectly. So I've just kind of mapped that out for you there on the first page. Okay. Now the judge goes into undisputed facts. Now, this is timely that I'm doing this because the judge organizes this brief just as you are organizing your briefs, right? This undisputed facts, he might as well have just said here, like what I tell you to write on the first page of your brief is the case facts. So he titles it undisputed facts. It's the same thing. And you'll see that the judge lines this up just as I want you to write your brief. So again, same thing going on right here. All right, so this is where we've got the facts. Jeremiah, you did a great job of summarizing this, so I'm not going to spend too much time on it. It's just Killian owns a condo. Ricchetti owns a vacant plot of land. The idea is let's sell the condo, take the money from the condo, invest it into the partnership, and then we'll have a partnership. And as you see down here, Ricchetti has referred to Killian as a partner, and that's important, mostly for evidentiary reasons. But this is where we get to it. This is it. This is the okay. I'm gonna chill out because you're like, Brother Hills is freaking out about a stupid case. And anyway, but this is exciting because this is real. And by the way, as an attorney, every contract dispute that I've dealt with, because as a corporate attorney, it's always business disputes, and the facts are almost always the exact same as this. All right, there's two parties. They think they have an agreement, but they never solidified it, and now one party's getting the raw end of the deal and is suing to get what he or she expected. I mean, this is classic. This happens all the time. And after taking this class, my hope is that when you enter into agreements or start a business, you're not going to have to worry about the same things that Mr. Killian is going to have to worry about. Okay. But this is where I start mapping things out, and I use blue, the color blue, for the first set of emails, and then you'll see I use green for the second set of emails, and this is extremely important. All right, so here on February 6th, Ricchetti emails Killian, so that's why I've got this right here. You've got the R representing Ricchetti, who is emailing Killian. Ricchetti says, and basically lists out the terms of the contract. What do we call it? Like you just blurt it out. What do we call this email from Ricchetti saying all of these proposed terms?
The offer.
Yes, Daniel, this is the offer. All right, so I'm gonna label this right here big. And maybe I wouldn't do this on my actual thing, but now you can see it better. This is the offer. Ricchetti says, I'm gonna purchase the senior lien on your condo, and then I'm gonna try to foreclose it. Right, and you don't have to understand the detail. That some students get really confused by this. Just understand that. Well, I'll tell you because I think it's kind of interesting. Killian, this all happened during during the Great Recession. All right, it started in 2009. By 2012, the market hadn't really recovered, especially in Philadelphia. And so what it looks like happened is probably before the recession, Killian purchased the condo, and then to get extra money, lots of people were doing this in 2006, 2007, 2008. They would get a second mortgage. They would refinance or, just take out a second mortgage on whatever equity that they had built in their home, which wasn't really equity because it was all a bubble, but whatever. They would get out a second loan on the equity of their house, and then they would have more cash. And they thought, this is free money. I'm going to invest this. And that's probably what Killian did. He had probably 2 encumbrances, 2 loans on his house. And Ricchetti said, I'm going to buy the senior loan, the first one, which he did. And then if you purchase the senior loan, sometimes you can force a foreclosure. And this was all, and the idea was, if Ricchetti buys that senior loan, forces a foreclosure on that pretty little condo that I was just showing you, that Wells Fargo, the second lien holder, the second mortgage company, would just give up and say, yeah, the house is underwater. We're going to throw up our hands and not not fight this, write it off. They just forgot that it's Wells Fargo. And if you don't know anything about Wells Fargo, they fight on stuff like this. And Wells Fargo wasn't going to allow this to go through and not get anything. So anyway, we could talk about that for now. That's another class altogether, but this isn't a real estate class. So just know the idea was force a foreclosure, get some cash, and then use that to buy into the other, the vacant lot. So that's where we get this 200,000 from. My pen died. 1 second. That's where we get this 200,000. And then the big one, 50% dual ownership, right? They would be 50-50 partners. And Jeremiah kind of lined this up because Killian ended up not being a 50-50 partner, and that probably broke his heart when you see how much they ended up selling the property for. All right, second, now here, 2 days later, now we're at February 8th. Now Killian finally responds 2 days later. And what do we call this?
Acceptance?
Yeah, this is the potential. I'm gonna write this small here. Potential acceptance. But we've got a major problem with the acceptance, don't we?
Is it counter offers instead of acceptance?
Yes.
It wasn't really an acceptance?
This is a counter offer.
Yeah, it was an acceptance because I've listed all of the, like, here, let me just mark this out so you
At least the new item.
Yeah, he started adding a bunch of terms. This is just like, Chong, if you and I if we had an agreement that you were going to mow my yard for $10, and then he responds by saying, yes, and I'm going to weed your garden for an extra $5, and I'm going to babysit your kids for an extra $20. And is that any acceptance? Of course not. That's just a new counter offer. All right. So yeah, let's mark off acceptance. And as the judge points out, we've got 1, 2, 3, 4, 5, 6, 7, and then, sorry, judge. I mean, I love this judge, but this needs to be an 8. He doesn't know how to number. All right, so now we've got 8. These are all things that were added on to the acceptance, meaning it wasn't an acceptance. It was just a counter offer. And as the judge points out right here, Ricchetti never responded to the counter offer. So we've got an offer, we've got a counter offer. What does that leave us with?
No,
Nothing.
no. nothing.
Two
Yeah.
offers and no acceptance.
Yeah. Say that again, Emma.
Two offers and no one accepting anything.
Exactly. We've got two blank
Brother
offers
Hales?
just shouting into the void and with no responses, no valid responses, no legally accepted responses.
Brother Hales.
Could you say that's like the smoking gun kind of a thing? Like that, those counter offers are kind of just, it's just kind of the gray area. And so that's kind of how it just escalated.
Yes. And I love this question because I think you're starting to like really get contracts. It's mathematical. This should make all of you accounting majors so happy. It's like you need this and then you need this. And if you don't have it, you got nothing. And so yeah, this is the smoking gun. It shows that they had an intent. It shows that they were negotiating terms. They just never agreed to it. Hence, you don't have a contract and nothing here so far is binding. All right. Brianna, did you have something?
It might be like skipping ahead, but do you think like his intent all along was to do this? Like, do you like, cause like reading it's very factual and like that's what the memorandum is, but like, I just like at the end of it, I was like thinking, I was like, do you think he knew all along that this is what he was gonna do? Because they both had attorneys, didn't they? And they sent
Okay,
like,
yeah. Brianna, you
So
caught
I'm like-
so much here and you're reading between the lines and I love this because yeah, hold on to it because this is also an ethical issue too. And remember, a major part of this class is ethics, which is why we talked so much in Theranos about Tyler Schultz and all of that. But we're going to come back because I think you're exactly right. There's a lot of ethical issues here. And Ricchetti looks a little bit shady to me. I don't want to like paint him in the wrong picture, but on first glance, let me say this. At first glance, Ricchetti looks like not the kind of person I would want to be my business partner. I'll leave it at that. Yeah, but yeah, awesome. Any other questions so far? Okay, well, let's move forward because, well, I mean, it's kind of easy. What we have so far is nothing. So let's move on here. All right, so now we've got a new, oh yeah, Chung, you had something?
I mean, like, this is the reason why we need to study business law, right?
Okay, good. This my wife makes fun of me, just so you all know. Like you're all thinking like Brother Hales is kind of a weirdo, but and you're probably right. But Laura's like, why are you so excited about contracts? And I don't know. This is my calling in life. This is interesting to me because again, like I told you, you'll face this in your life because I've seen it hundreds of times. All right. First set of emails taken care of. Now let's talk about the second set of emails. Here we've got February. So let's start here with February 19th. Again, starting with Ricchetti emailing Killian. All right. And here we've got some questions, but what it really gets down to is this statement right here. This is probably one of the most important parts of this whole case, is that Ricchetti says, when the pine is clear title, meaning, like just to interpret this, when we've sold that pine, that condo on Pine Street, then we'll form the LLC. You'll put in the 200 grand. We'll be 50-50 partners and blah, 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 blah. We'll go forward. But the big thing that the judge caught and that now all of you are going to catch because I've got exclamation points, like you can't miss it now. When the Pine condo is clear title, then we'll be 50-50 partners. So we've got an if and a then statement. This is your classic conditional offer. The offer, this right here, we could do this again, but all of you would have yelled out at the same time. We've got our offer, but we've got this big problem. At least if you're Killian, it's conditional and the condition never happens. All right. So sure, if you scroll down on the 20th, Killian responds, and this is a valid acceptance this time. We've got a valid acceptance, but it's a valid acceptance of a conditional offer. right? So we have a contract, but it's all conditional on the Pine condo being sold, which never happened. Remember, Wells Fargo, don't mess with Wells Fargo. Like there's two companies you don't mess with, and you'll learn this in the class as we go forward. One is Disney, two is Wells Fargo. Okay, so again, important life lesson, just taught it to you. Offer and acceptance, but again, conditional. Wells Fargo never let the condition occur, hence nothing. We have nothing here. It's just like, how long is this condition open? Like, okay, this is a good question for all of you to kind of think about. Let's say that Killian does sell the Pine condo in 2023. Can you go back to Killian or can you go back to Ricchetti and say, all right, the condition occurred, we're partners, 50-50. Can that happen? What do you
Does that
think?
mean more than 5 years? More than
Yeah,
5 years?
so Chung's got this idea of like me, that's too long, right? And that's, I'm seeing a lot of heads nodding right now, and I think you're,
Oh, sorry. I didn't mean to interrupt.
no, go ahead.
I think it would fall under a reason again, because we discussed last class that a lot of it had to fall under what would seem reasonable. I would say 5 would be reasonable, but that's only me, because contracts tend to last for years and years on end.
Yes, so
Like 20 years.
okay, I love it because you got back to that reasonable standard. How long is it reasonable to wait for somebody to sell their condo? And again, we don't really know. Now you accounting majors can get mad at me again, because what's reasonable in one case might not, like a time period in one case might not be reasonable in another case. You just kind of have to look at it. And here where we're talking about developing property, it's kind of like reasonable that it has to be done in order for that property to be developed. And how long is it reasonable to wait? It could be a month, it could be 5 years. This is just very fact dependent. So, all right, we'll move on. I think we've hit that second set of emails that I colored in green here. I think we understand that. Yes, it's a contract, but it's conditional and the condition was never met. All right, here, I think you'll like this. Here I put, this is where we found out that Killian has an attorney. Breaks my heart. This attorney is like the worst attorney and didn't advise Killian what was going on. And I'd like to point out, attorneys make mistakes all the time. But what I think the lesson here is that you, after this lesson today, you're all better contract attorneys than Killian's attorney, okay? Killian's attorney should have said, hey, show me those emails again, because here, now we know Killian had all of these emails. Sorry, Killian's attorney had all of these emails and should have said, hey, client, by the way, you don't have a contract because there's offer but no acceptance, and here there's offer and acceptance, but it's conditional. We should probably lock this down. You are all now better attorneys than this person, whoever it is.
Can he sue the attorney for the mistake?
Yeah. Good follow-up question. Yes, this is probably malpractice. So yeah, this doesn't reflect well on his attorney. All right. Okay. So again, but the attorney is probably thinking, I'm just here to form an LLC, blah, blah, blah. Anyway, but we kind of move down. This is where you get more talk about Wells Fargo, but we've talked. This is the judge just kind of going through the facts again, remember? And then this will be important later. Oops, came off again. The zoning approval.
Brother Hales.
Yeah, go ahead, David.
Yeah, I just have a quick question. I'm kind of going back when how often when there's like conditions in a contract does that hold? Because the other day you were talking about the basketball player who said, when I go to the NBA, I'm going to give you this money. But because it was like such a small chance of happening, it just didn't hold up in court. But like, how do they measure that? Like, was it so far-fetched to say I'll be able to sell this property that even if he would have sold it, that it wouldn't have mattered?
Yeah. Oh, David, I'm so glad you asked this, because you're right. These are two conditions that seem similar, but and so I could see why there's a potential for confusion. So I'm glad you asked. This one, okay. So with Allen Iverson, remember Allen Iverson and his high school friend said, when Allen Iverson said, you know, when I make it in the NBA, I'll share with you some of my money. And the judge said it threw out that case because that was so far-fetched. Like even though Allen Iverson was a great high school player, like the chances of him making it in the NBA are small, let alone being a superstar. So the chances are so minuscule right there that we're going to say that's just two kids dreaming, right? Whereas with this one, here you like the chances of you being able to sell your condo, that's almost a sure thing. Even in a recession, you could lower the price. There's lots of things that you can still do, and so it's not so remote, meaning it's not so far-fetched in this case, which is why it's allowed as compared to the Allen Iverson example. Other questions? Okay. All right. So yeah, that's a great question. All right. So now we get into the analysis. Again, just want to kind of bring this in. When you're writing your briefs, you have your case facts, you have your law, the issue in the law, and then you have your application, which is basically the same thing as what we're talking about. We could call this application. It's the same thing as analysis. So anyway, and here the judge goes through everything that we've already talked about. Goes through the February 6th and the 8th don't form a contract. The 19th and the 18th do form a contract, but there's this condition, kind of destroys the whole argument there. And here the judge goes through that in more detail. So we can kind of jump through a lot of this. Again, it just spends a lot of time being very detail oriented, which is what, remember, in your briefs, you don't have to write a 16-page brief, but be detailed. Go back and go through things step by step. The counter offer added new terms. Here's what the new terms are. I mean, the judge is repeating himself, but that's okay. That's what you have to do to be very detail oriented with this kind of thing. So again, oh man, this judge, I'm concerned for this judge. Did it again here. To the 7 when he meant to put an 8. Whatever. We'll forgive the judge. All right. And then again, Ricchetti never answered it. This is, like I said, this is just rehashing everything that we've already talked about. Okay. But now we get to something new, and that's here at section B. And this is the equitable claims. All right. This is what we call equity. And you have a number of equitable claims. I don't care that you have never seen this Latin term of quantum meruit before. Doesn't matter. It's just an equitable claim that says what happened to Killian is a little bit unfair. That's what equity is all about. Okay. So quantum meruit, promissory estoppel, unjust enrichment. This is just a way of saying, judge, it's not fair. I got taken advantage of. And the law recognizes that. All right. So if we scroll down here, I could even just ask you, what are the things that Killian did that he was never paid for? Things that helped Ricchetti, because remember, Ricchetti ends up selling that land and makes a hefty profit. And a lot of it was because of things that Killian did. Do you remember what it was?
Was it the zoning permits that they needed to get?
Yeah, he's got email chains with the city council, with the zoning and planning commission. I think they call it the Street Commission of Philadelphia. Weird naming, but whatever. He went to all of these meetings. He was basically lobbying to get the zoning changed. And if any of you have ever tried to get like something, a plot of land rezoned, you know this isn't like let me send a couple emails to the city department. This is not fun, not quick. It takes a long time. And Killian did all of that. So here, that's what the judge is talking about. Let's see. And undertakes efforts. Like this is all the stuff that Killian was doing, and Ricchetti even acknowledges, I could not have done any of this without you, Chris. Chris is Killian's first name. What this means is that Killian is saying, okay, I don't get contract damages. I understand that. We didn't have a contract. But it would be unfair for Ricchetti. Do you guys remember how much Ricchetti made off of the sale of the land? Here, let me just draw it up big.
Like $300,000
Yes,
or something like that.
750. Yeah.
Yeah, about 750. So, or 700, which means Killian.
I mean, they still have to pay the loan, but whatever.
Yeah. But
Didn't he want to do like 50,000 in damages or something like that?
Say that again, Taylor.
Wasn't it like 50,000 in damages that Killian wanted to file as well?
Yeah. So yeah, hang tight with that, because this is why Killian has a hard time sleeping at night for a while. If we go back to that very first set of emails, okay, I got to do this. This is why Killian is heartbroken over all of this. Okay. Not that one. Oh, yeah, it was that one. All right, so the blue one. All right. Remember, all that the offer was this, right? Like what you're seeing on the screen. We are going to place, like, it doesn't even say that we have to sell the condo. All it says is, I get the senior lien, and then we are what we call 50-50 partners. If Killian would have just responded to this first email on February 6th and did what he did on the second set of emails, and instead of adding all of these terms, if he would have just said, oh, not off, I can spell. There it goes. Of course, right here on February 8th, if he would have just said, of course, he would have immediately been a 50-50 partner. Okay, so why can't Killian sleep anymore? Because if he would have done that one simple decision would have meant basically he would be making, or out of this deal, what is half of 750? 325? No, that's not right. Is that right?
375.
375. This is why I wasn't an accounting major for you accounting majors. 375 he would have been entitled to that.
So just the question here is, maybe the first offer is unfair for him. Maybe it has some flaw. That's why he want to correct it.
Yeah, and that might have been disputed too, because whatever, but remember that first email chain never said anything about selling it. Just once I get the senior lien, then we're 50-50 partners. Crazy, right? But if Killian would have just said, cool, done, he would have been entitled to $375,000 upon the sale of Ricchetti's vacant plot on 2nd and Brown, right? But it didn't happen, and Killian can't sleep at night anymore. but is all lost for Killian, and that's why this is where we have a resounding no. Like Killian, he's not entitled to $375,000 anymore because he didn't accept the first offer. But he did a lot of stuff. He went to the planning and zoning. He met with people. He got it rezoned. Ricchetti even said, I couldn't have done this without you. And because of that, the law of equity steps in. Like this is what we're talking about here. Unjust enrichment means Ricchetti was unjustly, wrongfully enriched because of the stuff that I did, that Killian did. and I should get paid something for that. Now, he's not going to get $375,000. But at the end of the day, the judge says, basically kicks it back and says, I'm going to send this to a later hearing, and we're going to figure out what Killian should be paid based on all of this, on the equitable claims. Killian should be paid something. Now, if Killian was an attorney, this would be fairly simple. They would say, Killian, how many hours did you spend? It was 100 hours. And what's your hourly rate that you bill your clients? Well, it's 200, 300, 500 bucks, $1,000 if you're in New York City. And then the judge would say, okay, we'll just multiply how many hours you worked by your hourly rate. Ricchetti, pay him that, right? But this is a little bit more difficult. Why? Because Killian isn't an attorney, doesn't have a set hourly rate. So the question is, what's fair for Killian to get? My guess is at the end of the day, he'll get somewhere between 20 and he did. They settled this out of court right after this was published. He'll get anywhere between $20,000 and $50,000. I'm guessing it's probably closer to this. And that's fine. Like that's great. But really, this went to court, remember? So Killian's going to pay his attorney about 15 of that. So he's going to go home with about $5,000 for Killian. Whereas he could have had 375, right? That's
Birdhouse.
Yeah.
Quick question. At the end, did Ricchetti got the senior mortgage of Killian's property still, or not? Because
no,
I'm trying to understand like the whole deal with Wells Fargo, because basically, isn't the foreclosure is like when you don't have money to pay your mortgage or like the bank, then basically they take your property and they sell it out, right, for you. So then Ricchetti still had all like the senior mortgage of Killian because he paid for it, or this didn't go through.
So he bought that out presumably for fair market price for what that senior mortgage was. But because Wells Fargo never signed off on it, they just shuttered the deal. They never foreclosed. Basically, Killian still has that property. So when it is sold, Ricchetti does have the senior mortgage and could get repaid a fair amount, but is going to have to divvy it up with Wells Fargo someday. My guess is Ricchetti probably sold the lien, the mortgage to somebody else because they don't like each other anymore. Killian probably didn't want Ricchetti owning the senior mortgage. And to be honest, Ricchetti probably didn't want that either. So good question.
I have a question, Mills, really fast.
Yeah.
If he had said yes to that first email, about the 50-50, and then let's say he has said yes, of course, and then he sent his stuff to his lawyer, right? Mm-hmm. And he added that stuff to his lawyer, like that he had it on the email, but he added to his lawyer to put in the contract, plus the 50-50, and then presented it to his friend. Would that have been seen as a counter offer, or was still the offer?
All right. So awesome question. Just remember our jingle, right? Like offer, acceptance, consideration. Dang it, I sang it again. All right. Once you accept, it's done. Like once he had sent back and said, of course, then you have a binding contract. Now, the attorney may have written everything up and made it more formal, which the attorney could propose to Ricchetti, but that would be just a modification of the existing contract that already existed. So that's why that's a brilliant question, because yes, like the second that you say, yes, I accept, or yes, I offer, or give a thumbs up, or whatever is reasonably implied to be an acceptance, it's done. It's over. Like it is done. So yeah, you can always modify agreements with a new offer and acceptance, which is what probably the new documents from the attorney would have been. But yeah, just remember, once you accept, it's done. You've got a contract and it's binding. Okay.
Thank you.
Perfect. Good. All right. With that then, any other questions while I'm pulling up some top hat? Let's just run through. We've got 10 minutes. We can do a couple of top hat questions.
So when you go back the slide, can you go back on it a little bit on? Can you go on it?
Oh, yeah.
Go up a little bit.
Let me pull that up.
Yeah. If you scroll to the would deny summer judgment. Actually, you passed that.
Oh.
No. Last page. Yeah. So there's a title in bold. We deny summer judgment. No, no. Up again. There's a title in bold. There's a subtitle in bold. Yeah, this
All
one.
right. So this one, right?
So I don't really get it. So they actually deny the summer judgment or deny the claims. So they deny the claims.
Yeah, don't get hung up on this. So what happened is Ricchetti was saying, summary judgment, judge, I win, grant me summary judgment. And the judge said no. Why? Because Killian's got some legit claims here.
Okay.
Yeah.
But this part they say they deny the claims, right? Claims.
Yeah, just because those same issues are dealt with.
So what exactly this mean though, the subtitle?
It just means, okay, so yeah, Killian also said, give me summary judgment, give me equitable claims and this amount of money. And the judge said, no, he denied that summary because he said, summary judgment request, because he said, we have to figure out what it's worth. So it's not that Killian just wins outright. It's just that the judge says, there's some issues here. It needs to go to court. And because when Ricchetti heard that, Ricchetti said, oh, I should just settle. I should give Killian some money instead of taking it to court. So that's why Killian ends up probably getting in the ballpark of 20 grand.
Oh, I see. Oh, thank you.
Yeah, no problem. All right, so now, while we've got some time.
Hey, Brother Hills, another quick question.
Yeah. Yeah,
go
ahead.
For contract disputes, for it to last like 4 years or so?
Say that again?
Is it typical for things like this to last so long in court?
Yes. Yeah, this is something else you need to get used to. I mean, the courts were backlogged before COVID-19. Now expect to wait many, many years until you get it before a judge. It's just how it is. Now, most people don't complain about it because it gives you a couple years to get all of the facts for your case and kind of build up a case. Just remember your attorney is billing $500 an hour for that whole 2 years. Anyway, it's a blessing and it's a curse. It allows you to build a good case, but it takes a long time for cases to get in front of a judge. A couple years usually. All right, good. Yeah, darn it. So anyway, that's why I've got this question. Let me just kind of show you what the question is. I'll always ask students, like, who won this case? Was it Killian or Ricchetti? Let's kind of jump ahead because we've covered it. But the idea is nobody really won. Like Ricchetti's probably the overall winner. He could have had to turn over $375,000 to his potential partner, but he didn't because the partner never accepted. So, but he also kind of lost because he had to pay off Killian something. So Killian, and it's just kind of an interesting thought issue. Let's go to let's do this one. So this is a consideration question. Just want you to, no, let's not do this one. Well, no, do it. I want you to do this one. Think through it. This is a kind of difficult. I'll give you a minute and a half. Just so you fully understand this, Emma works for a company. A competitor comes into town. Her current boss is like, oh, crud, I'm going to lose Emma to this new company. So I'm going to make her sign a non-compete, and just gives Emma the non-compete to sign. No explanation, nothing else. Emma is worried that if she doesn't sign it, she's going to lose her job. So she just goes ahead and signs it, saying that I'm not going to go work for the competitor. So we've got a new contract, an offer, and acceptance. The question is, was there consideration here? right, so got about 30 seconds to wrap this one up. Oh, sorry. There it is. All right, so you've all answered. Let's see what we did here. So of the responses, okay, interesting. All right, some people say, 18 people say no because Emma gains nothing in return for the non-compete. And then the other kind of top contender is D, no, because the existence of the contract is causing Emma to be afraid for her job. Both get to the same place though. I'll just show you. A is going to be the right answer here simply because you're right. Like, and this is interesting. You're one of the first classes to ever overwhelmingly pick the right answer on this. Probably why you got higher grades on that first exam than my other sections, but this is impressive. Yeah, Emma could sign it, but it's not binding. Why? She didn't get anything out of it. Like, if the boss would have said you're all fired unless you sign this non-compete, that increases the chances of it actually being a binding contract, because yeah, it's there. Now some of you are like, well, that sounds like duress. Was anybody thinking that? Yeah, so some nodding heads. Well,
more like undue influence, but
yeah, undue influence or duress. Interesting, right? Because I guess there's a chance for that. But remember, it doesn't really count as duress if you have the right to do that thing anyway. Right? Now, putting a gun to somebody's head and saying, sign the contract or I'll shoot you, that's very different because they don't have the right to shoot you. Whereas when we get to employment law, you'll see most employers have the right to fire you for any reason, and maybe sometimes no good reason at all, unless it's an unauthorized or illegal reason. But we'll get to that later. So again, yeah, she could. So but I mean, the end result, like the lesson of this is, if this ever happens to you, you could sign it and just kind of chuckle to yourself and say, I didn't get anything out of this. There's no quid pro quo, no consideration. It's not binding. You could quit. Emma could technically quit and just go work for the other company when they offer her more money. So interesting little case there.
Hey, Brother Hills, could you use emotional duress or procedural unconscionability?
Procedural, probably not. Think of procedural just as like the small type situation, the Santa Claus movie example. But undue influence, remember, you need to have a vulnerable person. And Emma probably isn't considered a vulnerable person. She's a top salesperson, supposedly a sophisticated business person. And with those assumptions, which I think are all logical, she's not a vulnerable person. And so I don't think that it would qualify for any of those. Yeah.
So what would someone have to get out of a contract like this?
Yeah, great question. It would just have to be a raise, a bonus, more job security. Now you're not an at-will. Now you've got some. Anyway, it's just they're just like, it could be a lollipop, for crying out loud. Like here, have a lollipop if you sign this non-compete. Don't ever sign away your life for a lollipop. I mean, we've got messes of porridge, like in scriptural examples of that. So don't do that. But it's a good lesson there about consideration. And remember, judges won't go into like is this consideration really worth the non-compete? They won't do that. As long as there's something, even something small, they'll say, okay, Emma got consideration for this, so now it's binding. Whereas under the facts given you here, probably not. Yeah, good.
So what if I guess if the employer does say, sign this or I'll fire you, and she signs it, is there some sort of to the agreement? Does it expire after a certain amount of time? Does that have to be explicitly written into the contract? Or if she ends up leaving someday because she's just like, I don't want to work here anymore, and then she goes and she works at a coffee shop for 6 months, and then that other company finds out that she quit her job and didn't go directly to them, is there a way, like after 6 months or a year, if she goes to work for that other company, does that now is that other contract void, or is it still in play?
Okay, so it depends on a lot of state law issues. So everything, a lot of employment law is just, it's going to be laid out by state law. In general, they can. There are statute of limitations with these things, and there's also reasonable standards with all of this. So that's the short answer. The long answer, I'll just say wait till we get to employment law, because we'll cover a lot of this in a couple weeks. When is it? We get to employment law June. Like June 19th is when we get to this. So it's fun. Employment law is interesting, and it deals with a lot of stuff like this. So anyway, it's 12:30. Let's go ahead and end this right now. But stick around if you have questions.